Dr. Abhishek Singhvi.
Mr. Chairman, sir, I rise in support of this bill and I wish to make some suggestions and comments. We should be very clear that we are discussing an important subject, an important bill and an important commission. There can be no two views about the vital importance of human rights, and we should be a happy nation that on the whole, a nascent institution like the National Human Rights Commission, under a relatively new act, has discharged its functions and role reasonably creditably. It has achieved international recognition and status within a relatively short time, and most important, its views and decisions have greater moral authority than mere legal efficacy. That it is done so is partly because of the objectivity and the impartiality and the great detail of research which it has brought to bear upon its task. The life of any legislation must be periodically reviewed. It's a constantly evolving, dynamic process, and it is good that after these few years of the NHRC, we have brought in an amendment in the light of experiences gained, in the light of the constantly evolving situation. The proposed legislation has several positive features, and we all know about that, so I'll not take time on that. But just to mention and highlight, it is very useful and important, for example, to amend the definition of the international covenants, because in international law, no single instrument carries universal effect, no single instrument carries universal authority. A host of international instruments relating to human rights create a corpus of international jurisprudence which becomes both practice, convention, and is followed by all the nations. And now that this act amends the definition to include that entire corpus of international law generating instruments, in a sense, we are going to adopt and go not by minimalist standards, but increasing the standards to somewhere nearer maximum standards. And that is very good. Secondly, the provision regarding surprise visits, surprise checks, surprise inspections is also very welcome. I think it was more by oversight than by design that the original one intended that there should be full notice. I happen to have been a counsel in the D.K. Basu custodial torture, custodial deaths case, and the crux of the guidelines which the Supreme Court laid down regarding custodial torture or custodial death was surprise visits at jailhouses, at police stations to check such abuse. So I think that is again a very welcome and laudatory amendment proposed. Thirdly, the power of the NHRC to transfer matters to state commissions is also a beneficial, useful provision. After all, the NHRC is only one. It is an apex institution at the national level, and it declogs the system if it has the authority and the power to decentralize adjudication to the various other state commissions. That again, I think, is something to be welcomed and applauded. Sir, may I come to three specific issues where I want to make suggestions and partly agree and partly oppose those who have spoken before me. The first issue is, and on this issue I broadly agree with the speakers before me, that perhaps the power for any adjudication body or magistrate or munsif to refer to the NHRC may not serve the purpose it is intended to. There are different kinds of courts all over the country, and to permit a reference by anyone at any time in any court to the NHRC may perhaps impliedly, without quite intending it to be so, dilute the status and authority of the NHRC. It may also open the floodgates for a huge number which will become unmanageable by the NHRC. I therefore have a simple suggestion for the Honourable Minister to consider, which will in fact achieve the purpose which this bill seeks to implement and yet not open the floodgates. Human rights issues arise in public law, and public law is administered in our country by courts which are known as writ jurisdiction courts. Under a constitutional article 226, certain courts exercise power of an extraordinary nature to issue writs. Now, since that deals with human rights and public law issues, it might be best to make a small amendment and to provide that the reference to the National Human Rights Commission can be made by all courts which exercise writ jurisdiction power. Additionally, of course, the Supreme Court can always refer to the NHRC, which it has already been doing. So this twin power of allowing referrals by courts at the High Court level exercising writ jurisdiction plus the Supreme Court will suffice to achieve the purpose which the minister seeks to achieve without opening the floodgates. Moreover, if it is intended that even lower courts should be able to refer to the NHRC matters arising, then perhaps another simple additional amendment can be made saying that the lower courts may refer such matters to the High Court of that state, to the bench exercising writ jurisdiction, which may then in its wisdom decide whether the matter deserves to be referred to the NHRC. There will be this additional filter which I submit will both not open the floodgates to the NHRC, it will provide a filter, and since public law and human rights issues have to be administered in this country by courts exercising writ jurisdiction, it will channel such references through the appropriate forum, namely the High Courts exercising writ jurisdiction. So this is the area where I broadly agree with the preceding speakers, but with the amendments and suggestions which I have made, which I believe will also achieve the purpose which the minister seeks to achieve. Second area, before I come to the contentious area of Chief Justice, retired or judge, the second area I think which needs to be thought out is a little technical, but I must address that. Interim relief could be given by the NHRC earlier also, and it is being continued by the amendment. There is no change, which is good. However, earlier compensation could not be specifically given. Now we have provided that compensation can be awarded. It seems to be a good thing, but let me raise a few questions which I think can be easily met by amendments to make it efficacious. We must not forget that the NHRC as it today stands before and after the amendment has only recommendatory powers. It has no enforcement powers. Secondly, compensation can normally be awarded after full adjudication by a decree. Compensation means you have adjudged, adjudicated, found one party guilty or innocent, and then awarded money. Now, both these things the NHRC does not do and cannot do under the present Act. It does not do a full adjudication, it cannot pass a full decree, and whatever order it ultimately passes is not enforceable. If that be so, to merely provide that compensation may be granted may create two problems of a serious nature which may not have been foreseen. Today, because the NHRC can't give compensation, the person is at least entitled to go to the normal civil court and seek compensation. And in that civil court, he will get a decree which he can enforce. Now, if he goes to the NHRC and gets an order of compensation which he cannot enforce, he will be both without a remedy in the NHRC and he will not be able to go to a civil court also, because you cannot have dual remedy or double damages on the same cause of action. So I think the solution will have to be either provide at least for the case where the NHRC gives compensation, at least in that limited category, provide that its orders will be enforceable. That will complete the circuit and complete the picture. Or alternatively, do not provide merely for compensation without enforcement. Leave it to the ordinary civil forum where he can seek compensation. Otherwise, it would be a hybrid, half of nothing or half of either side. Sir, may I now come to the last but the most contentious point where I totally disagree with that which has come from the opposition benches and from some other speakers prior to me. It is suggested that the amendment to permit judges other than the retired Chief Justice of India to hold the post of chairperson is a prejudicial amendment, a undesirable amendment, a erroneous amendment. Sir, with utmost respect, I totally disagree. And let me approach the problem a little differently. Let us not forget, sir, that in this country we have several statutes, a very large number of acts, and I can recite any number of them from the Excise Act to tribunals to income tax tribunal and hundreds of tribunals. The important point is hundreds of tribunals in this country are manned the norm is that only by retired judges, either of the Supreme Court or of the High Court. It is very interesting to remember that the maximum revenue in this country perhaps comes from excise tribunals, because excise generates the maximum. Nowadays, a close competitor is telecom. In the excise field, even a Chief Justice of a High Court is not required to head the tribunal. A judge of the High Court is sufficient. So let us not forget that the norm for 90-95% tribunal in this country is a retired judge, frequently only a retired judge of the Supreme Court, or frequently only a Chief Justice of a High Court or a retired judge of the High Court. Number two, therefore, the provision that it should be only a retired Chief Justice of India is by itself an exception. It is itself an exception. What is now being done is to bring the exception by amendment back to a norm. There is another very important facet which my friends on the opposition have forgotten. In the Supreme Court, every judge is equal. The Chief Justice of India is only the first amongst equals. The junior-most judge of the Supreme Court, in terms of seniority, exercises exactly the same powers as the senior-most judge of the Supreme Court. Are we, sir, in this debate forgetting that we trust the matters of the greatest moment relevant to this nation to any judge of the Supreme Court? We trust matters of national security. We trust matters of immense public revenue. We trust matters of immense political importance. We trust matters of very momentous importance to individual parties, all of them to a judge of the Supreme Court. The only extra power which a Chief Justice of India has is that he has the power of allocating work, of fixing the roster as to which judge will discharge which subject matter of duty. The Supreme Court, for example, sits in roughly 10, 11 or 12 benches. Each bench is independent completely. The case which they are hearing is entirely in their control. The underlying premise of my friend's argument is as if there is a hierarchical difference between the Chief Justice of India and other judges of the Supreme Court so far as powers or competence or talent or authority is concerned. This is the fundamental fallacy of the entire argument. My friend has a habit of not being available after finishing his speech as far as reply is concerned. That also happened the other day. But that is for him to decide and is conscious to decide, not for me to comment on. Not for me to comment on. Therefore, Mr. Chairman, sir, in a sense, without I am sure intending it to be so, my friend on the opposition is really making an insinuation or an allegation against normal judges of the Supreme Court who are not Chief Justices, which, as you know, can be only one. Therefore, I think this constant harping on the fact that a judge of the Supreme Court is in any manner exercising truncated power, circumscribed power, limited power, or in any manner is less qualified than the Chief Justice of India is itself the fundamental fallacy which arises from my friend's arguments. Ultimately, sir, we must not forget that it is the individual who matters, not his designation. A judge of the Supreme Court can be outstanding. A Chief Justice of India may be average. It all depends on the kind of person you appoint. Vice versa is also true. Vice versa may also be true. Therefore, it all depends on how well the committee, the selection committee which is already in place and to which no one is objecting, will choose the candidate. Therefore, let us not put so much moment, let us not make insinuations of candidate of choice as far as a mere change from CJI to judge is concerned. After all, we are talking of the very high status of a Supreme Court judge. Let us, sir, also not forget a practical difficulty. At any point of time, the pool of persons you can select from is in fact extremely limited if you limit it to the Chief Justice of India retired category. This is a fact of life. It's not good enough to say that there are always enough. In fact, what happens is that a person retires at 65, there is a person already in place, he may retire after 2 years. After 2 years, the available pool may be only 2 or 3. Now, in place or as opposed or by contrast to a pool of only 2 or 3, if you have a pool of 20, 25 persons of the status of a Supreme Court judge, no less, I think there is absolutely no cause for apprehension or complaint, and there should be no doubt. This is really an unfortunate innuendo or suggestion created as if there is some kind of a diminution of standards while forgetting that very high tribunals, and I gave the example of the Telecom Tribunal, which is very high revenue earner, only a judge of the Supreme Court is to head it. The Excise Tribunal, not even a Chief Justice of the High Court is to head it, only a judge will suffice. Therefore, sir, may I suggest in conclusion that this bill, which is undoubtedly a very significant and important bill, deserves to be considered constructively and passed with the two suggestions which I have made as far as reference to the NHRC is concerned and as far as the compensation issue is concerned. I submit, sir, for your kind consideration of this August House, that no change is required as far as the pool of potential candidates is concerned, and that amendment is very salutary, indeed is desirable, necessary. Sir, I therefore move this bill for consideration along with the suggestions which I have made. Thank you, sir.